This we have not interfered with the finding of the Honorable Single Judge as regards the termination. We have upheld that, but we have clarified how his pension should be given. We have said that his pension will be only for the period he had served, that is 82 to 98. That will be the qualifying service, but you will treat him to have been retired in 2019. But pension will be only for that period only, that much. Because we have taken into account his conduct also in the earlier proceeding. You will get it after some time. No. What is it?
Your Lordship, I beg to mention item number 3, 4, and 6, Your Lordship.
3, 4, and 6.
Yes, Your Lordship.
This is similar matter or what?
No, Your Lordship. They are different, Your Lordship.
Then?
Additional General, Mr. R.S. Naram, due to some of his health issues, he is not unable to come today, Your Lordship. May it be taken after 2 weeks, Your Lordship.
2 weeks.
Yes, Your Lordship.
Your Lordship, for item number 4, if the matter is fixed on December 19th, because the council will come from...
We'll list after 2 weeks. Then you make a mention if it doesn't come.
Right. A fixed date would be...
No, if it is not listed, you make a mention after
sir.
2 weeks. All right.
All right, sir.
3, 4, and 6.
Yes,
3,
Your
4
Lordship.
days. Separate order, huh? Mr. Vairida, Learned State Counsel, appearing on behalf of Mr. R.H. Naba, Learned Additional Advocate General, submits that the Learned Additional Advocate General is undergoing medical treatment. Therefore, praise for listing the matter after
2 weeks, Your Lordship.
2 weeks. Praise the Lord. List the matter after 2 weeks. Separate order, huh? 3, 4, 5, 6.
No, Your Lordship. 3, 4, and 6, Your Lordship.
3, 4, and 6. Okay.
Obliged.
Obliged.
Your Lordship, I beg to mention item number 5.
5.
I, on behalf of T. Omos.
T. Omo.
Yes, Your Lordship.
Your for
Respondent.
respondent. What is to be done? It's in the order.
Your Lordship, he is out of station. Therefore, he is asking for give it to 3 weeks.
You wait for some time. We'll see. It's in order column. All right.
Yes.
Your Honor, in item number 2, Your Honor, in service copy, there is certain mistake, Your Honor, which
Not mistake. There's nothing. How you can file a PL like this? This is for allotment of contract.
Yes, Your Honor.
Already allotted. It's been more than a year.
The work is
Works
already...
is going on. You withdraw or will impose a cost.
No, Your Honor.
Then
Your Honor, maybe take this on next bench, Your Honor.
why? What is the mistake?
There is certain...
PL is not maintainable at all.
Your Honor.
There can be PL like this. You know what is the matter?
Yes, Your Honor.
Wrongly or rightly, work has been awarded. It's going on.
Yes, Your Honor.
So what's the question of filing a PL?
Page 15, 17, 15. What's the 15, page 15, after the bold question. But the respondent authorities had by pick and choose basis by depriving the others issued work order to the private respondent who were not even qualified for shooting.
Are you a contractor?
No, I am a social activist, Your Honor.
Are you a dummy? Dummy of subcontractor?
No.
Proxy?
No, Your Honor.
Will impose a cost. Will grant you today, think over it. Next week,
Bless you.
dismiss with cost. What mistake you have committed here?
No, Your Honor, in their petition, Your Honor, there is certain page.
They are not objecting. They don't want. They'll go with.
No, departmental, this taposer, Your Honor, the standing council.
Huh?
In standing council petition, there is certain mistake. So we need to change the pages, Your Honor.
So you will go by the advice of the standing council in filing the PI.
No, that mistake is from our side, Your Honor. That's why we
Who is
need.
appearing? Who is your senior? Are you appearing in this matter?
No, Your Honor, the
Who will argue the matter?
Simodi.
Call him, will dismiss him. Dismiss it with cost. Nothing. You are a proxy contractor
My Lord, may we heard
or
this
a
matter
dummy.
on. My Lord, may we heard this matter on next bench.
Next bench.
Yes, Your Honor.
On the prayer of MS
Tirimi.
T.
Rimi.
Rimi, learned counsel for the petitioner. List this matter next week.
Yes, Your Honor.
Tell your senior.
Yes, Your Honor.
It may impose cost.
Yes, Your Honor.
Such PL cannot be encouraged.
Tell you what my lord is trying to tell you is that the pleadings that are there on record shows that you are a contractor, not a PIL.
Yes, Your Honor.
Tell your senior that.
My Lord, in here, my Lord, that ULB department, town planning department.
You are for petitioner.
I'm from
You
petitioner.
have not taken steps.
I have taken the step, but last occasion, Your Honor, my Lord, this town planning has objected that we have not mentioned in cost title their part. That's why the court has directed to amend us, but the same is not reflected in the order. That's why the registry not allow us to do the same, Your Honor.
So what is to be done today?
My Lord, maybe pass.
Office note indicates that you have not taken steps.
Your Honor, there is no private respondent, only department.
No. It says on the notice, service of no notice, steps. You are supposed to take some steps. Maybe some correction or whatever.
Yes,
You do whatever you heard. MS so and so learned counsel for the petitioner.
Your Lordship, actually, I was appearing for Tiomo Musa, so he's out of station. Therefore, he's out of station.
Who?
Tiomo.
You are Mr. So learned counsel for the petitioner. Learned counsel appearing on behalf of Mr. Tiomo. What respondent number?
So there's I don't know that because I'm not with him as a.
I'm sorry. You are not supposed to appear without knowing anything. At least we're not asking for the facts of the matter. Even in fact, you should know the facts of the matter. Well, very sorry. Did you join the bar?
Actually, I'm not with him as a senior, but I'm in the.
You have not joined the bar?
Yes, I've joined, but Your Lordship.
When?
Last September, this 2000.
Last September 2020.
This is the third time appearing in High Court.
So you have talked to your senior. This is not the way to send the junior. All right. So and so for this is office note dated 29/11/2023 reflects that steps has not been taken by the petitioner.
my Lord.
It is not for service or whatever. We don't know. Whatever you want to take, you take. Today, what do you want?
My Lord, may reflect in order that we are allowed to amend the course title.
Will not say. You file an application for that.
Yeah.
Anyway, so and so learned counsel for the petitioner submits that she may be allowed sometime to file appropriate application for amendment of the course title. Mr. Prayer,
Bless you.
Mr. So-and-so for respondent number, appearing on behalf of POMO. For respondent number so-and-so. You are appearing? Mr. Before that, Mr. N. Rathan, learned additional lady. Respondent number, check it out. One entry. One entry.
Matter may be kindly taken up on 14th of December. 14th of December.
On the prayer of Mr. X-Gyati, learned counsel for the petition, list this matter on 14/12/2023.
Okay, all right.
Thank you, Your Lordship.
Yes.
My Lord, I'd like to mention item number 19 to 24, my Lord. Yeah, my Lord, this matter will be fixed on 6/12, my Lord. Some analogous matters. These matters may be listed up on 6th December, my Lord.
6th December.
Yes, my Lord.
Why?
Because some of the analogous matter are fixed on that day, my Lord. Some of the analogous matter are fixed on that day, my Lord. Same.
Okay. What's the matter?
It's termination, my Lord.
Termination.
Yes, my Lord.
It's a lot
APPSC.
of problems. Have you filed the
Yes, ma'am.
affidavit? You have filed the affidavit.
In some of the cases, we have filed, my Lord.
To others,
Other,
you check it out and file it, and you fix it.
yes, ma'am.
Ms. T. Wang, learned State Council. Praise for it, granted. No, praise for listing the matter on 6th December, 6/12/2023. Item 19 to 24.
Yes, my Lord. 19
Item
to
19 to 24, Praise the Lord. List this matters on 6/12/2023. Yes.
May I please, Lordship? The Lordship, I beg to mention on behalf of the Jama Lordship, I beg to mention item number 6, Lordship. Item number 6, Lordship.
6.
6, Lordship.
Okay.
Lordship, this matter may be listed on 20th of December, Lordship. And
Do you have the consent?
Yes, Lordship. I have taken consent from the opposite party, Lordship.
Mr. So-and-so, learned counsel, appearing on behalf of Mr. T. Jama, learned counsel for the respondent. On consent, praise for listing the matter
On 20th of December, Lordship.
20,
20, Lordship.
listing the matter on 20/12/2023. Praise the Lord. Listed matter on 20/12/2022. Yes.
And Lordship, item number 7 and 7, 10 and 11 also, Lordship.
7,
7, 10 and 11 also,
10 and 11.
Lordship.
All consent.
Lordship. Lordship, here we are waiting for instruction from the department.
No, my lord. In fact, I'm appearing in item 11, my lord. I have not been informed about this. But my lord, otherwise in item number 11, my lord, on the last order, they were supposed to file and today it was supposed to be, the interim order was supposed to be
Well,
considered.
terminated, what interim? You will ask them to file the affidavit and disposal.
Lordship.
You have already terminated. It's been
Yes, of course, my lord. It is there.
nearly a year.
My lord?
It's nearly a year
No, my lord.
after the termination. When you were
It was,
terminated.
in fact, when it was moved, it is hardly 1 month, but it was not even a month, but now I think it has been around 2 months now.
You could have fervently and vehemently prayed that day.
On that day, I
What-
prayed, my lord, in fact, but on the prayer of the Mr. Jamo that we will file the affidavit by next day, then it can be disposed.
Yeah.
So that was why it was,
So you go for that better. The unnecessary, I mean, it's like difficult to turn back the clock.
of course, my lord.
Termination.
Yes, ma'am.
All right.
Then, my lord, then may I pray, my lord, item
Then
number.
one by one, just one.
No, man.
Item 7, same order on consent, right?
Lordship.
Okay, then item 10,
Lordship.
no objection.
No,
Same order.
there's a status quo.
Not what do you want in this? 7, same, 28.
7, Lordship, no, Lordship.
7,
After 3 weeks.
what is your prayer?
Listed after 3 weeks. We are waiting for instruction from the department, Lordship.
Mr. So-and-so, then you have to have the separate order, different order. Appearing on behalf of Mr. T. Jamo, Learned Standing Council, Education Department, submits that he may be granted 3 weeks' time to file affidavit in opposition. Whereas just after 3 weeks.
Leave
Whereas
it.
to enable the Standing Council to file the affidavit in opposition. Item 10,
Lordship, same, Lordship. After 3 weeks, Lordship.
3 weeks.
Status quo may be continued.
Interim.
Status quo.
This is interim. Transfer matter.
Transfer method, but
You have not been released.
no.
You are a teacher.
Yes, Lord.
Substantive.
Lordship.
Your post is teacher.
Give us
Your
this.
substantive post is teacher.
Yes, Your Lordship.
Go there. Go to school. Where?
Lordship. I have been attached for the Directorate of Elementary Education.
You have been attached. Now the department wants that as a teacher you to teach the students in the school.
Lordship, they
Go
were
there.
supposed to file the affidavit.
Why?
It's not been-
Why you are delaying it? Of course, Jamo is not there. Would have disposed it of, dismissing the writ petition.
Lordship,
You are a teacher.
Lordship.
Go to teacher. Can I ask you, being a learned lawyer, to treat the patient as a doctor?
No.
No. It's just a temporary arrangement.
Lordship.
You have to, or else if you are not interested in teaching,
Let
Give it
them
a-
file
gi-
the
gi-
affidavit, Your Lordship.
give it up. Give it up. Anyway. Same prayer, huh? After 3 weeks. You have to file,
yes, Lordship.
dispose of.
Obliged.
Leave it, Lordship.
Item 11, what to do then? 2 weeks, we'll give you 2 weeks.
Lordship, as instructed by the Tijamo, Lordship.
On the first day, T. Jamo has learned Standing Council had sought for a time for instruction,
Lordship.
right? Today is fixed for consideration of interim prayer.
Lordship.
Where is?
Lordship, he is having health issue, Lordship.
Is a fit
Doctor has,
Young-
Lordship, advised him to take a bed rest, Lordship.
address.
Lordship.
Seriously.
Lordship.
3 weeks. Let it be after 3 weeks, my lord. This praying asking for 3 weeks.
This okay, learned counsel for the petition. Mr. So-and-so, learned counsel, appearing on behalf of Mr. T. Jamo, learned standing counsel. Press for and granted.
3 weeks.
Press for and is granted.
3
2 weeks.
3 weeks, Lordship.
Why? It's a termination. You are a regular employee.
Yes, madam.
Termination is just by issuing a notice.
Only notice.
Prior to-
A probation period I have already completed, my lord. All the so cause notice, they have said that we will follow as per the CCS rules, my lord. Then nothing done, my lord. And difficulty for the here is that, my lord, the order has come from the commissioner, my lord. So we cannot go to the appeal also, my lord. Whereas my disciplinary authority and appointing authority would be DDAC. But if it was passed, I could have gone on appeal also, man. But now the appellate authority, in fact, the commissioner has passed the order and the DDC has merely conveyed the order to us without anything. Man.
We'll fix it next week.
Okay.
You pray, press your interim prayer. Because we cannot, this court finds his prima facie, we could have considered, but since standing counsel is not there. Next week, can he join next week?
Sir, Lordship,
You try it because prima facie, the termination appears to be illegal. It has not followed the procedure. Next week you try. In case if he's really, sick and seriously indisposed, then you make your arrangement. Next week, then in that case you heard so and so, huh? For standing task. List this matter next week for consideration of the interim prayer of the petitioner. As this court prima facie find it to be not in accordance with rule. No, not in accordance with law. However, since the standing counsel is reportedly indisposed due to his sickness, let this matter be listed next week.
Okay.
My lord, item number 25.
Yes,
My lord, I'm mentioning on
I
behalf.
cannot take up this. List this matter before any other appropriate bench without me.
Oblations.
Similar, the similar related matter I appeared somewhere.
Okay. Your Lordship has appeared on behalf of the state, Your Lordship, in this matter.
So what?
No, Your Lordship.
Either of the parties.
Yes, yes.
But what was your prayer?
My lord, my prayer were that my senior has instructed me to take after the matter may be fixed after the 4 weeks. So for you.
I cannot take up this, therefore I passed out. All right.
Okay. Oblige, my lord.
May I please, Your Lordship?
Yes.
Your Lordship, I would like to I beg to mention item number 12.
12.
Yes, Your Lordship. Your Lordship, may the matter be adjourned for today and
You are
for Learned Counsel and Duncan.
Hmm?
For Learned Counsel and Duncan.
Learned Counsel
And Duncan.
and Nangan. Okay. On the prayer of Mr. You are here. What's your name?
PC ka.
Mr. So-and-so, Learned Counsel, appearing on behalf of MSN Duncan, Learned Counsel to the petitioner. Press for and is granted. 3 weeks.
3 weeks. Ma'am.
3 weeks time.
Obliged.
Estimate of 3 weeks time. Thank you.
May I, my lord?
Yes,
My lord, I beg to mention item number 14, my lord.
14.
14, my lord. I'm for respondent, my lord. On behalf of all parties, my lord.
We'll see. This order is this. It's in orders column. We'll see. Wait for your turn.
Okay, please.
I'm sorry, Lordship, in the item number 12, there is an interim order. It may be continued.
12.
12. Ma'am.
Interim order earlier but shall continue.
Obliged.
Yes, yes.
My lord, here, the respondent authority has filed their affidavit, I need to reply, my lord, because here one of our contention was two documents, site visit and program chart, was submitted, not of the package, not of the place, my lord. They are submitted from the another place. But now in affidavit, they are saying they have submitted the right one, my lord.
You are in item 2.
Two, my lord, yes.
One is you are not interested.
No, my lord, we also need some time to file a reply to
It's a
that.
motion. We have not admitted. We'll dispose it off. There's nothing. Or you withdraw and file a fresh petition. On the basis of the affidavit, there's nothing. What reply?
Either one.
You said they just rejected your bid without assigning reason. They have now assigned the reason. If you can challenge that, it's okay.
No, my lord, I have two contentions. One is that they have, I have been not treated equally, my lord. They have submitted the another documents, my lord, not as per the SBD, my lord.
It's
And they should have been also rejected.
no, the nature of the prayer you made in the writ petition,
Yes, my lord.
simply quashing and setting aside, praying for setting and quashing it will not enough of the rejection. There should be some materials to quash the rejection. So by this petition, this court is of the view that there is nothing. You have been rejected on grounds of dismiss, nothing. You may, we will, nobody will prevent you to file a fresh petition. Of course, subject to, liberty granted by this court.
That's true, my lord.
It's better to withdraw and you file a fresh petition.
Otherwise, my lord, either one of petitioner or respondent authority is lying, my lord.
That's
As per-
why.
As per documents, my lord.
But then you are not able to establish by this writ petition that there seems to be lying.
No, my lord, I've annexed the documents also, my lord, here.
So what?
They should have been rejected, my lord.
Then we will not issue notice even. Because this court finds it privacy.
So then, my lord, so that I can reply to the affidavit. If otherwise,
but-
it's issue is very serious, my lord.
If you insist, that's why I'm saying, file a better petition. Bringing all those things, because you have given whether to make out a case better
That's true.
than this writ petition.
That's true.
Nothing will be there. Nothing you will not get anything.
So,
This
my
by this petition.
uh,
Choice is yours. I can compel you.
well, then let it become upon 4, so that I can take instruction from my clients.
Mr. K. Tariq, learned counsel for the petitioner. In item 2, and Mr. So-and-so. You write, and Mr. So-and-so in writ petition 544/2023. Then Mr. So-and-so for writ petition 547/2023. Item 1. Also had Mr. G. Tarak. Then Stanley Constable RWD for all the response.
My lord, yeah,
It's spread by the Stanley Council. Next para, the Mr. G. Tarak. Affidavit in opposition has been filed. Mr. Could I record my view? Will it have a adverse effect on you on next day?
I pray that may not be recorded.
What do you say? But I have gone through your writ petition and the affidavit.
Yes, that's true, my lord.
That is it.
Yes.
That's the reason we insisted him to file the affidavit within this very, very short time. Because the nature of your prayer, the nature of the writ petition which you have filed, that's the reason. This court thought after 12 years then nothing, either will dismiss and if good sense prevails on you, I thought this court thought that you will withdraw and file a better petition.
So therefore, my lord, let it fixed on
So should I record that my finding?
objection.
Yes.
No, I leave up to my lord.
Anyway. What is that? As spread by the London Standing Council, huh? You just delete, you start afresh. As spread by the London Council for the London Standing Council for the respondent. On which date you have read? Day for yesterday.
Yes.
On 28/11/2022. Affidavit in opposition has been filed. Have been filed in both the writ petition. Mr. Herbert, the London Council for the petitioners submits that they may be given an opportunity to reply the same in view of the above and the nature of the grievances, nature of the matters involved in this writ petition, in these writ petitions. Without come up, without issuing a notice. The Learned Council for the petitioners are granted 1 week or 2 weeks.
1 week.
1 week to file their affidavit in reply.
How long?
Same thing.
Same thing, madam. They have not given me the order, the rejection order.
I have on 3 ground, he has been rejected.
This is a different project.
Yes,
Yes.
the same project was different package, different district.
Different package.
Yes.
Different place, different work.
Yes.
Same, all, these are all same thing. Let him file an affidavit. You file an affidavit.
Yes,
Please tell about all these matters.
No, madam,
This is something different or what?
something different. We have to, this whatever court may kindly
In that
satisfy,
case-
whether the grounds are whether reasonable or not.
Let us see. What is your grounds of challenge?
Madam,
ground is that he has been not given the reason.
Okay.
no reason has been assigned while rejecting my bid. Only a simple textual message.
Okay.
So I seek writ of certiorari to, well, the issue communicated.
This is yesterday's
Yes, yes,
unlisted matter.
yes, yes, madam.
What is the procedure after rejection? Normally, we find that you upload in the
My lord, I am now clearly told that during the time of opening of technical bids, all the participant bid can inspect each other's document, but due to none of the party, they insist to inspect all the document. After inspection, the registration, EMID, then they said, okay. Then after that, the authority will upload and print out all the bidders document, and they will start evaluation. After that, then again, sometimes it used to close. NIC they used to do. Even it is
after the
Down-
rejection, after the rejection,
after rejection, that rejection only result will inform. Then inter detail evaluation result can be. This is minute he can obtain from the authorities. Then that statement
so no longer the documents which the bidders submitted
upload
will
that,
no longer be in the portal.
that will close.
After downloading it from.
Yeah, hard copy will be at in the
Before
division.
evaluation.
Yes, hard copy will available in with the authority. He can apply for that.
My lord, can I-
Only it is not your case that you have not been allowed to inspect or you have not given the documents which is lying with the respondent authority before and after. Your only case is that you have been given a message through the message that your bid has been
No, we
rejected
were not given-
without assigning reason. Number one.
Number one.
Now they have come with this instruction
Yes, my
with the reasons that on what ground you have been rejected.
lord.
Correct.
My lord.
Number two, you said
We
you
was-
could not access to the portal,
Yes, my lord.
the papers or the rejection
Yes,
or the minutes of the committee,
yes.
technical bid evaluation committee. What about that? Suppose documents, as you said, may not be there
Not there.
after downloading. It's closed. That can be obtained
Yes.
physically or whatever.
But minutes will be there.
Minutes should be there.
Yes, yes.
Have you checked out the minutes?
No, man, we
Because
were
in
not
the
furnished.
minutes, the message is something which is not permitted. I mean, so ought not to have been.
Yes, ma'am.
In other cases, through email only, it is given.
Yes.
But this has been given a message, also,
Message, ma'am.
text message.
Yes, ma'am.
Now, that is, it's not proper, but then just because if we call it, mere aberration.
Madam.
Yes.
That is, you may be correct in that case, it was not proper. But so far as the minutes, where it contains under what clause and what provisions of the SBD you have been rejected, then you can always access. He said it's there.
No, madam, we have submitted representation. They have not furnished us, madam.
Hmm.
And the third one, madam, they have not informed us when the technical bid is going to be opened, madam.
There is something.
Because in our absence, the technical bid was opened, madam.
I don't think.
Then in that case, we'll not issue a notice. You file a.
Yes.
All right.
Madam, yes, my lord, yes, they may be directed to furnish me this copy, madam, of minute, madam, because I can challenge it, madam. By giving life to this writ petition, my
Then
lord,
you withdraw, you file a fresh petition.
my lord, I will file amendment petition, madam. Amended writ petition, by challenging this in minute, madam.
So in that case, we'll say,
Allow me to participate for now, madam.
huh?
My prayer is for interim, my lord, allow me to participate. My financial bid may be open, madam.
Unless we say, we find it your rejection is prima facie illegal.
Yes.
My lord.
How we can direct
Yes.
you to participate? Sorry.
That communication was itself illegal, my lord, because it was not
That's
reasonable.
why I said this code is of the beach. It's just maybe regular or it's a mere aberration.
My lord.
That Jagdish Mandal and all.
Yeah.
But even if there is an irregularity,
My lord.
unless you can show the arbitrariness and the illegality,
My lord.
glaring illegalities.
Well, this textual message itself is glaring illegalities, my lord.
Manifest arbitrariness.
Because in most of the cases, the reasons have been given. I was not given
You
any
know,
reason, my lord.
They are supposed to be through email, but then the ultimate the result would be what? To
Right.
convey you that you have been your bid has been rejected.
My lord.
Either this way or that way.
Well, the equitable justice requires, my lord, I may be allowed to, my lord, participate, my lord.
See,
Financial bid, my financial bid may be open, my
It's
lord.
a tender
I will
matter.
challenge, my lord.
It's a tender matter.
That's why, my lord,
No
let
equity.
me participate, my lord. Let me participate.
You have already participated.
No, no, let my
Participate
financial
is
bid be open, my lord. I will challenge this technical, my lord. Technical bid, my lord.
Challenge it.
My lord, yes, my lord, but my lord, in case, in the United States, my lord, my matter may, my writ petition may become infructuous, my lord.
Disjudgment.
This judgment would be a long procedure, my lord.
It's good for the lawyer.
My lord. But the prima facie, my lord, in that
So what
case,
do you want? You want time to file amendment petition? We can, I can ask him to share this copy.
yes, my
No
lord.
issue.
Yes, sir. He may be directed, my lord. I will file my amendment writ petition, my lord.
Heard Mr. B. Piche, learned counsel for the petitioner, and also heard Mr. Peter, learned standing counsel for Urban Lady, for all the respondents. The scope on 29/11/2023. directed the Learned Standing Council. That will be next para, huh? To obtain instruction. Today, Mr. Learned Standing Council. Please,
May I submit?
instruction.
In that case, my lord, I may be allowed to withdraw because your lordship will not be giving any observation, my lord. So I may be allowed to withdraw the writ petition with liberty to file a fresh one. Let him direct to furnish me the records, my lord. Every minute.
No, once you withdraw, I'll
Yes.
be able to ask. Anyway, as a colleague, you just furnish it. It's not a, secret document. Is it a
Due to
secret-
non-furnishing of
is it
this document, my lord, I have filed this writ petition, my lord. My lord, due to non-furnishing of the documents, my lord, I have filed this writ petition, my lord.
What is the records? Instruction, place the instruction along with the, what is this? Grounds of rejection,
Detail statement.
detail checklist for,
Okay.
place the instruction by, Mr. So-and-so has placed the instruction with the, including the copy of the checklist for evaluation of technical bid. And then submits that the bid of the petition has been rejected on non-compliance of the required clauses of the SPT. This court has directed the Standing Council to share with the copy of the checklist for evaluation of technical bid, which he did. Give it one.
I'll get it Xerox in here.
List. After going through the checklist as shared by the London Standing Council, Mr. B. Feature, London Council for the petition fairly submits that he may be allowed to file, he may be allowed to withdraw the writ petition to the liberty to file fresh. Mr. Next page. Where is the allowed?
That record will be kept by this honorable court, madam. As a record.
Have you heard the order? I have said you have been shared on perusal only. You have decided.
But what I am saying, madam, this record may be kept with the
This
case.
will be withdrawn. You file a fresh.
What?
Allowed the praise allowed. List is accordingly this writ petition is still this writ petition is still closed on Woodward with the liberty. You take it back. Give it quick.
If that can be part of the record, madam, that would be much better.
This you have withdrawn this.
No, madam, that record.
No, that is recorded that I have directed the Standing Council to share with you. You get it, one copy. Give the copy now. He may have some doubt.
Let me get it Xerox.
It appears that he's not, he doesn't have any trust on you.
Yeah. Maybe change the record. Oblige, madam.
Sir, what is this?
My lord, this is pertaining to non-payment of the compensation, my lord.
What compensation?
Here, my lord, what happened? The petitioner has 8 nodes of LPC land.
Where?
It is in 2007 and 2008. Issued by the Deputy Commissioner, Lower Suburban District 0, my lord. That is Annexure 1, page number 41 to 56. And this is a LPC issued in my name, my lord.
This has been acquired or what?
My lord.
Land has been acquired.
Land has been acquired and work has been already executed.
Huh?
My land has been illegally acquired by the executing department, my lord. They are constructing some 7 nodes of tower lines, my lord, transmission lines. of 132 kV for monopoling that is within 0 power station power grid from 0 to actually, my lord. So they have already erected, my lord, and my line has not been acquired. And that tower lines which passing through my LPC, my lord. And I have
This is construction of what?
this 132 transmission lines, my lord.
Yes.
Sometimes it's called in the pylon structure. It is also called a pylon structure, my lord, which passing through my land, LPC land, my lord. So in this regard, when the matter was executing, I was lodged a complaint before the Deputy General Manager of Power Grid, which is stationed at 0. And also I have submitted application before the Deputy Commissioner, Lower Subansiri District 0, for compensation as well as for relocation of that tower post. Maybe some other place, maybe erected in.
What is the procedure?
My lord, first of all,
it has to pass through someone's land.
Yes, first
If you
of all.
don't want that, it should not pass through your land.
Yes,
over
my
your
lord.
land.
Yes.
From where it will go?
So
Other person will also.
no, so my lord, before acquiring my land, first of all, a preliminary notice is to be published. Section 11 of Right to Fair Act, my lord. So for survey purpose, preliminary notice is to be issued, my lord.
What is is there any provision?
My lord.
For installation of transmission lines, you have to acquire the land and the compensation has to be paid. What is the procedure?
My lord, in case of private land, my lord, that
it has to be acquired. Compensation has to be paid.
My lord.
Then you pay.
Yeah.
That is the law. That is the procedure. We are not paying.
For my lord here, but for my lord, respondent, my lord. Would be my lord. I am representing my lord respondent number 4 only, my lord. In this case, my lord. 4, my lord.
Who is 4? Who is the main party?
Main party, my lord, would be my lord Power Grid, my lord. Sorry, Power Grid, my lord, and State, my lord.
Sir, Deputy Commissioner only they have a party. Yeah. So I'll be representing Deputy Commissioner.
At this stage, my lord.
Who has to pay the compensation?
My lord,
Suppose
here
if you are
Power Grid.
In case you are entitled.
Yeah, respondent number 1 and 2, my lord.
Who is the respondent 1 and 2?
Is the chairman managing director, Power Grid, my lord.
Okay.
And Chief General Manager, Power Grid Regional Office.
Secretary Power.
Yes, my lord. And the Secretary.
So issue notice.
This is
Yes, my lord.
And Mr. N. Pezi, Nilam Pezi, Learned Counsel for the petition. By filing this writ petition, the petitioner has prayed for what is your prayer?
My lord.
Prayed for compensation. Acquisition of land of the petitioner for installation of
132 kV transmission lines from monopoling at power station 0 to Yachule.
Mr. N. Pezi, Learned Counsel for the petitioner, submits that the petitioner is the owner of the land for which various LPCs.
Yes, my lord. 8 nodes of
in the
LPCs.
name of the petitioner. the authority would have adhering to the provisions of the Land Acquisition Act has acquired the land and the and the and it has been proposed or it's already been.
It is undertaking, my lord. Most of the land has been already covered, my lord.
Okay, has allowed the respondent number 1 and 2.
1 and 2 and 3, my lord.
1, 2, and 3. To install a transmission line over the land of the petition. Issue notice, returnable in 4 weeks. Mr. L. Permit, and standing counsel for the conduct, enters appearance on behalf of respondent number 3. 4. And MS D at the senior registered representative for respondent number 5. This the respondent number 4 and 5 are duly represented, no formal notice needed. Other extra questions so the learners consent for the respondent number 4 and 5. Steps be taken for respondent number 1, 2, and 3. Is after 4.
May I please? The lords have already.
Same order.
Same order. The date of
Same
the.
order or date of.
Only one thing will be different, my lords. The dates
Yes,
of the
yes, yes.
notices.
My lord, here I am appearing on behalf of all the respondents, my lord. My lord, there is from the record, my lord,
Wrongly, rightly, this court has already in similar.
My lord. Now, my lord, in
That
the
order, my lords, I have attached at page 360.
360.
360. My
so
lord.
therefore, my
The
lord,
date of the notices, my lord, here will be.
Impute order.
My lord, impute notice here.
Impute notice.
Notice. Date is 21/7/23
Impute notice dated.
and 24/8/23. 21/7/23. My lord, 24/8/23.
Where it is? Where it is?
Yes, my lord. It is at page number, my lords, annexure X. Page number, my lords, 344.
344.
344.
Impute notice.
Yes, my lords. And second is.
Order, what about the order?
My lord, order has not been passed.
No order.
Order has not.
Only notice.
Only notice, yes.
my lord,
Impute
he is
notice.
only
Impute-
challenging the notice, the
Yes.
proceedings, my lord.
No, not only
Right.
notice, my lord, the entire procedure, illegality,
Yes, ma'am.
not following the procedure, notification, everything.
Proceedings are going on.
Absolutely.
Proceedings are going on.
Yeah, that's right.
So therefore notice.
Yes, my lord.
So the other case, it was the order has.
Yes, it has already converted into the order. my
In
lord.
the earlier case.
Yes, my lord. My lords are right.
Then you contest here.
My lord, we have given, my lord, what is
Notice,
happening?
Let us see the notice.
Yes, ma'am.
In that case, page.
Same thing, my lord. Absolutely same issue.
Page
Page 344.
344.
In fact, my lord, what happens is they first issue a first notice, we have replied to it. Now this is the second notice. So they call it pre-notice and the show cause notice. So pre-notice we have already replied, my lords.
What is the next process?
My lords,
After this,
then they have to pass an order,
they
my
will
lords.
pass order.
It is a fait accompli, my lords. They have already taken a stand, the same officer, and one is a lower ranking officer.
Notice, first you issue, you reply to this and.
My lords, I have already replied, and what he notes is,
No, if they pass an appropriate order, then you come back.
my lords, what my submission is, I filed a reply to the notice, my lords. My lords, that notice. my
Against
lords,
this?
Yes, my
Impute
lords.
notice?
Kindly see, my lords.
Impute notice.
Page 327, my lords.
No, whatever this notice, demand comes so-called notice.
My lord, what
21/7.
prior to this, my lord, they have issued a pre-consultation notice. My lord, may kindly have that page
No, it's
327.
okay. You reply this.
My lord, the only thing is,
What is the requirement?
I have no difficulty, my lords, I'll reply.
Will
But
not-
my lords,
Will
the-
not assert the
Yes, my
power of the authority.
We are not, my lord, because what we are saying is we are challenging.
Maybe it appears to be a formality.
It is an absolute formality. It's an absolute formality. They have already taken a view, my lord.
No, my lord. This
My
is
lords
a
have seen.
Premature
Just
stage.
hold. No, it is not. It is not. Why, my lords, I say this? There is a reason, and that I have pleaded everything. Number one,
just issue notice. No stay of the
my lord, only one thing. Let me say. One thing, my lords.
It's not the same thing. Maybe the process has yet to be completed.
What I will submit before my lords is I have submitted to their jurisdiction. Though, but my lords, one of my prayer is that the notification is bad on the strength of which they are relying. They cannot decide that. Number one, my lords. Number two, my lords, the same officer is passing the order or an officer who is junior to him.
In that case, you reply it.
I will reply, my
Will
lord.
issue notice.
So therefore,
simply will issue notice.
Yes, my lord.
You reply the notice.
Yes, my lords.
In case they pass an order,
Yes.
you can.
My request, my lords. My request. My request in that case would be, my lords. My lords may say that they may pass an order, and that order may not be given effect to. I have no difficulty. I have submitted.
Not say that.
My lords, why I am saying is ultimately, my lords, what is happening? My lords had noted it on
the process
my lords,
has
it is
yet
not,
to be.
why I am
in
saying
other
is,
cases, order has been passed.
my lords, why I am saying is, my lords, may kindly consider it for a moment, my lords. Why I am saying, my lords, I explained on the first day. Defense, my lords, gives a contract to BSNL. BSNL.
It's okay. We'll look into what those.
My lords, I am only praying this, my lords.
We'll issue notice.
My lords, what is happening?
Reply to the so-called notice.
I'll reply, my lords.
Notice.
I have replied already, my lords, and what he notes, my lords, kindly see what they are doing. Only one para, my lords.
No, it's okay. This court is.
No, my lords, may pass this order only.
No. If I am going to pass this order, why?
No, I am not saying that order. I am saying my lords may only issue notice, but my lords may see this thing. One thing, my lords may see with me, my lords. My lords may kindly have that, my lords.
I have seen it. It's okay.
My lords, what is happening is, my lords may have one circular of theirs.
Mr. Agarwal,
my lords, there is an easy.
Sorry.
My lords, there is a complete illegality in this, my lords.
Yes.
One aspect, my lords, may consider they have issued circular 2 days before only.
That's why, prima facie, in the other cases, we have issued a notice. I mean, state order.
My lords, what is going to happen? My lords, I
Let
ask
the process.
I fully appreciate, my lords, and I am grateful to my lords.
You
Only
come
one.
back.
My lords, I'll come back. There is no difficulty. Why I am saying this? My lords, will only give me one moment. My lords, these are all highly loss-making companies. Demands after demands are being raised, my lords. The entire net worth of the company is, my lords, not even 100 crores, and demands are more than that, my lords. The net worth. And they are all making losses after losses, my lords. Ultimately, my lord, this issue is, my lords, are seized of this issue.
Heard Mr. P. Agarwal.
My lord, only one thing, allow me to show that, my lords. When I file a reply, they are saying I have not even filed a reply, my lords. What will I do? I'll go. My lords are directing, I'll go. But please allow me to show that one thing. Thereafter, my lords may ask my friend, why are they not even considering reply? They say, we have not filed a reply. Reply is on record, my lord. If that is the way they are going to make.
That's why we are issuing a notice.
If
you file a reply to the impugned notice.
I'll do that, my lords. But my lords may protect me in the sense that they will not recover the demand. I have no difficulty, my lord. I am not saying that they will not, and I'll separately impugn that order also. There is no problem.
What is the procedure of recovery? How do you recover?
My lords, they can seize my bank accounts and all. There is a complete procedure, my lords.
No, before passing any orders, they
yes.
Not.
Before passing this order, my lord,
no, before passing the final order, they'll not. This you have been given a.
No, before passing order, they will not.
That's
Definitely
right.
not.
Right. When the
moment, so I am saying, my lords.
The moment they pass the order,
yes,
will come back. All right. Heard Mr. P. Agarwal, counsel for the petitioner.
Lots of paper demands are being created. Lots 4 times.
And also heard Mr. M. Kato, DSGA.
For all respondents.
For all respondents.
My lord.
Okay. Next paragraph. By filing this.
But only that protection, my lords, may consider.
The petitioner has challenged the proceedings. You are challenging only the notice now.
No, my lords, I am challenging all the notifications and everything. It is the same. My lords, may kindly have my prayer, my lords. That is at page number.
I challenge the proceedings and SCS dated 21/7/2022 and 24/8/2023. By which the petitioner has been denied the benefit of ITC due to delay in filing of returns.
Sir, one judgment can I show to my lord?
We'll see at the time of hearing, not now.
Lord, what they are doing, these
Not now.
huge demands are.
No,
lords.
no.
I have paid that tax.
You have to.
I've paid that tax.
The petitioner has also challenged the impute notice. Where it is?
Yes, my lord.
Where is the notice?
Yes, my lord.
Page?
Yes, my lord. 244, 344.
344.
And my lord, the second one is a 353.
Impute notices dated 21/7/2022. As well as, and
My lord, 353.
353. 24/8/2023. Issue notice for returnable 4 weeks.
Lord, may fix the same date, my lord? 21st?
21st. Returnable by 21st, 21/12/2023.
12. So, my lord, in that case, notice may be given for 3 weeks, my lord, because otherwise 4 weeks are not there in between.
3 weeks. 3 weeks. Huh? Next one.
Lord, my only request is they may pass an order, I'll participate, but that order may not be given effect to me. I'm not saying that let them.
Come back. We cannot, preempt now. Authorities.
Lord,
cannot
because I am
preempt.
challenging
We'll
jurisdiction.
We'll examine the legality and validity.
That's right, my lords are examining that.
Not we're going to stop the authority.
No, I'm not stopping. That's why, my lords, I'm saying let that order not be given.
Cannot preempt it. They may, on
Lord, but they have the same authority. My lord.
who knows, on your reply, they may appropriate order in your favor.
Always.
Also.
In that case, my lords, my one submission may be recorded.
The petitioner, in the meantime, the petitioner is permitted to reply to the impute notices.
Yes, sir.
If so advice. List on.
Yes, my lords.
No entry.
My lords, but
We'll
Reply
consider
like
if
yes.
order is passed, you
Yes,
come back.
yes, madam. I'll do that. My lords may say that notice is issued on my stay application. Notice may be issued on my stay application.
We'll see.
All right, grateful. Grateful.
What is this?
This is, we are seeking for NOC, my lord, from the department, Deputy Commissioner, my lord.
Why you are not giving NOC?
Lordship.
What's the problem?
Lordship, his conduct, Lordship.
Hmm.
This is for deficit.
Hmm.
NOC is for deficit, not for other purposes. Here, Lordship may come to page 23.
What is his conduct?
Lordship, while in the post of Lordship.
Affidavit. Your
no,
affidavit.
No, Lordship. In the
Have you filed the affidavit?
No, Lordship.
Then
Lordship.
you want to file or you don't want?
Lordship, we are yet to receive.
Okay.
But then page 23, Lordship may kindly peruse also. Page 23.
Page 23.
Yes.
Yes.
In the verification report, Lordship.
It's already flagged.
Yes.
What does it say?
While in the seat, Lordship, he has given allotment to himself, to his mother, to his wife, in just adjacent to the CO office, Lordship. Rumgong. While he was posted at ESC. After transferring from this place, only his name is being sent to DPC, Lordship. For that DPC purpose, they are not giving NOC.
With this number one finding.
Lordship.
Number one finding.
No, 2, 3, all this.
First is what?
First is, Lordship,
allotment was given to
his mother, Lordship. The said plot is located adjacent to the circle office at Jomlo Mobuk and falls within the government notified area of circle headquarters. The government
what does it say?
circle places
his mother.
Yes.
Where is it say?
Lordship.
Mother is not there.
No, in favor of Srimati Yatartaga, wife of Tayartaga, Lordship, in the second para, Srimati Yatartaga is the mother of Sri Tagamevang episodes. He is the petitioner here, Lordship.
Oh, Srimati.
Yes. And again, para 2, Lordship, 401 has been issued to the MITI permit. This is.
Have you initiated deferment proceedings?
Lordship, that's why we have conveyed if any instruction, Lordship, we are yet to receive. Lord. And then, Lordship,
If you have not initiated any proceedings against him, how can you deny this such type of
Lordship,
action?
in the DPC,
Wrongly, rightly, if
because
you
of
find that
NOCs are denied for DPC in the if their conduct is this way, Lordship,
where
or
is
the
the provision?
officers, Lordship.
Conduct before proving it.
Lordship, this is the verification report, Lordship.
That's why I'm asking, if you, on the basis of if you have initiated action and if the proceedings are pending, that may be a ground, but if you have not done just because he has allotted in her name or whatever, get on the ground for denying the NOC. If you have initiated, if it is pending, that we can understand. Is not it?
Lordship.
Am I wrong? What do you say?
Lordship, we have already conveyed to the Deputy Commissioner and the
No,
personal
what do you
secretary
say?
personnel,
According
Lordship.
to you, you
Lordship.
assist us. This is my view, of course, on hopefully in accordance with law.
Lordship. Lordship, one chance may be given. I will,
Just because
bring a
report and
proper-
allegations is there, unless there is a department, any case pending against him, either departmental or criminal, whatever, you cannot deny. So right to permission for, right to consider fundamental right. I thought of disposing of this matter, but since you have no instruction what to do.
So far, we have not.
It's not
instruction, Lordship.
permissible, this sort of action. Who is stopping you from initiating proceedings? If this is really the report, is not it? What to do?
My lord, already they have taken enough time, my lord.
So today what should we do?
Maybe dispose this matter.
You know, just like. But why you have allotted land in your in favor of your mother?
No, my lord, see
This is completely you are liable for departmental proceedings.
my lord, just see the same page.
Total
after-
conflict of interest.
No, my lord.
Mother
Misconduct.
himself.
No,
Three
not my,
allotments, Lordship.
not my mother, my lord.
Report said it's your mother. Are you denying your mother? Disowning the mother.
My lord, she was wife of Tayor Thaga, my lord.
She is not your mother. Second line, second para. She is the so and so is the mother of. It's strange. You are disowning your own mother. We are craving for, all of us craving for a mother. One person who lost their mother. Including this court. And you are disowning. Very unfortunate. Heard this thing?
He comes in.
He comes in, learned counsel for the petitioner. Next para. MSG at the London Additional Senior Government Advocate. Senior Government Advocate. Press for and is granted 2 weeks time to.
Yes,
file
my lord,
the
1 week.
in the plan.
1 week.
2 weeks.
2
1
weeks,
week, she will not. You send a reminder.
Yes.
This is not permissible. Though you can, you have ways and means. But then you are not doing it. Just because there's a, you cannot deny it.
Lordship, I understand. Agree. Oblige.
Lordship, we need time to file affidavit here, Lordship.
Affidavit.
Lordship.
Or Mr. So-and-so, London Council. MS Arbor, London State Council, respond is granted 3 weeks time to
Lordship.
file affidavit. After 3 weeks. I cannot take up this matter. It's BC, through BC. Yes, Lordship.
In this case, my lord, I am yet to receive extra copy, my lord.
No, it's to connect it. In view of the strict direction. You cannot deny anyone, including the lawyers and the litigants, to appear to this. Yes, Mr. Pandey.
Yes, sir.
I'm sorry, this court cannot take up this matter. And related matter, this court appeared when on behalf of the respondent at earlier point of time.
Yes, sir.
All right.
Yes, sir.
Heard Mr. Pandey, S. Pandey.
Yes.
Learned counsel for the petitioner. And also, no, sorry. In that case, I cannot pass any order. List this matter before any other appropriate bench without me.
A date may be fixed, my lord,
No,
if possible.
No, if I cannot take up, I can pass any order. You make a mention later.
My lord.
I have filed my reply, my lord.
Huh?
I have filed my reply, my lord.
You
To the
filed a
affidavit,
reply.
yes, I have filed. To the affidavit in opposition filed by state respondent and private respondent.
Okay. So this is for admission.
Last occasion, your lordship was directed to obtain instruction.
Yes.
Lordship, my instruction, Lordship, I have spoken to the undersecretary and then the concerned district commissioner. They said they will, since there are other departments also, they say they may be given some more time to discuss the matter so that they can come to a conclusion.
We'll record
Because
this
there is
over-
no other way around other than Lordship giving them. I have already told them there is no option.
So we'll not record that. It's okay.
Yes.
We'll just adjourn it on understanding. All right. On the joint prayer of the learned counsel for the petitioner, list this matter after 4 weeks, so as to enable the respondents to
Take instruction.
take appropriate steps.
Lordship, Lordship.
It maybe includes everything.
Yes.
Discuss and work it out.
Yes.
Because you are not disputing that land belongs to them.
Yes, Lordship.
Of course, there may
Yes.
be some kind of thing that they have already donated.
Yes.
So if had it been a simple donation, they would not have any right.
Yes.
But there's no documents to show also.
Yes.
But practically they have donated with the hope that the contract work and the government job.
Some appointment of lines.
Last week of December.
4 weeks. Let them have a fair discussion. First week of January or second week of January. They'll be busy New Year and all those.
Second week of lines.
2nd of January.
No, second week.
2nd week of January.
Second week, Lordship, I may not be able.
Then first week of January.
Lordship.
First week you listed, we will not say first week of January, give that date. Then make it 3rd week. So that they can properly
It's very much. of-
discuss and all
Yes.
evaluate themselves. 3rd week,
of January.
give the date,
Yes.
3rd week. Yes, next.
23rd.
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 of lines.
Name, please, madam.
Yes.
This one part and matter, madam.
Madam, you go call Mariam. Mariam is the call Mariam.
Here, the petitioner is minor, challenging the minor departmental proceeding dated 25/2/2020.
Yes.
And pursuant to that minor proceeding minor, the private respondent has been promoted to the post of assistant minor. Minor, the respondent authority is basically a minor, an agency minor, duly funded by the state government and the central government. That's why minor, this writ petition has been filed to attract the Article 12 of the Constitution of India in a state minor. And basically the minor, the agency is APEDA minor, is a registered society, registered under the Societies Registration Act minor. And their management and the rules and administration is being guided by the minor, resolutions minor, adopted by the minor, governing body, or sometimes it is called minor, board of directors minor, for any minor appointment or promotion minor. And the board minor makes the rules under minor article minor 14 of the memorandum minor. Minor before
Just before that. This 1/11/2022 order, where this court would like to have a instruction that whether this assistant is a group B or group C post.
We have already filed additional activity.
To that
So
extent,
saying
they have
that
filed
this is group B.
Group.
Okay.
they have
There's
not,
no dispute.
no, my lord. They have filed and my lord, a compilation of the my lord, report of the pay commission, my lord, saying that my lord, this scale bears this group, my lord. But they have not said that, my lord, whether, my lord, basing on the pay scale, my lord, that has been adopted by the agency or not by a resolution, my lord.
That is the important.
Yes, my lord.
Because this, it will have a relevant.
So far, Losip, classification,
Because they are disputing.
Yes.
So you have to come up with clear, not just because of that. Just because of the
Pay commission.
recognition. So this is treated to be, and all know that, but it is an agency. This is an agency. You have to come up with a clear stand. And so that they can rebut also. Have you rebutted? Have you filed a reply?
Reply, my lord, we filed the reply, my lord.
You have filed a reply.
My lord. When I have placed the judgment, my lord, even when I was assuming, my lord, the groups, any group C post has been merged with the, my lord, group B, my lord. Then there has to be, my lord, for that context also, my lord, the rule has to be, my lord, amended, my lord. Then I have the judgment, my lord, with me, my lord. Now they are saying that earlier, my lord, it was a group C post, my lord. Now say by virtue of the, my lord, recommendation of the pay commission, it's a group B post, my lord. If it is a group B post, my lord, then also, my lord, the rule has to be amended for the group B, my lord.
You have accepted the sixth pay commission. Is it as per sixth pay commission?
So,
Have you accepted the recommendation?
we said government has already accepted.
So it applies to you.
It applies to them also.
Yes,
Agency also.
That's admitted.
the scale is applied to us, my lord.
According to you, why this is?
Losip, so far this classification is
Just
concerned.
wait.
So far classification is concerned as regards to the pay scale loss. How Losip, whether it's group B or C or is classified loss. The basis is the pay commission loss. Because pay scale given which category the particular pay scale belongs to loss. That has been classified in the this pay commission loss. So group B, C, D, everything are classified as per this, which is applicable to everyone loss. Since it has been adopted by the agency loss, so very classification is also applicable to them loss, the sixth pay commission loss. And sixth pay commission says loss, this particular pay scale loss, it falls under the group B loss. And if losses see the pay scale of the petitioner, that is the post of assistant in the appellate loss, that bears the losses same pay scale which falls under the group B loss. And so far, we need to understand losses how it has been classified. As I'm losses apprising this on call losses. This is only the pay commission, central pay commission loss. Once it has been adopted, this is the basis on which losses.
But
Those cases, I have not seen those cases, but that could be a cases where the rules has to be amended. Maybe a rules frame under 309. This is your rule is not 309.
309.
Is it 309?
That's why, my lord.
Is it 309?
No.
Your rule is not 309.
No,
It's on
Article 34 by resolution.
Memorandum of Association.
Yes, my lord. That's why, my lord.
There is a difference.
Yes, there is a difference.
Is it as good as the rule made by the executive?
My lord.
Not the statutory kind of thing.
No, my lord.
Neither in the under the act, statutory or provision or the constitution. Your role is something it's as good as executive. So
Yes.
there is a difference.
No, it cannot be treated as an executive.
No, see, once you have accepted the state government has accepted the recruitment, the sixth pay commission recommendation, and you made it apply. It applies to you also. It applies to the department, the agency, is not it? So will it not be is there any notification or the resolution by the board accepting the adoption of the state government? or acceptance of the state government? Is it automatic?
Well, I will answer in that way, my lord. Assuming my lord and my lord, it's a group B post, my lord. My lord may for time being forget it, my lord. It's a group B post, my lord. Now, my lord, I am basically challenging the DPC, my lord. DPC, proceedings of the DPC, when the rules were in existence, my lord. Whether it is a 309 or the rule made by the my lord, the board of directors, my lord, by a resolution, my lord. Because it's a registered society and the my lord, rule has to be made by the my lord, by the my lord, board of directors, my lord. For that, it is an statute, my lord. Now, I will come to that, my lord. The rule provides that, my lord, for promotion to the, irrespective of, my lord, it's a group C or B, my lord, now. The rule which was applied at the time of, my lord, DPC, at the time of consideration, my lord, was, my lord, 2013 rule, my lord. It was not amended, my lord. It requires, my lord.
Has it been amended now?
No, my lord. Till then, no, my lord.
But it's also, rules also said the post classification of the post. It's a group B or group C.
C. It's a
Group
group
C.
C, my lord.
That's what I'm saying. That's a relevancy.
Yeah.
Suppose if we rely on the rules
My lord.
for promotion,
Yes, my lord.
we just cannot ignore the rules,
Yes, my lord is absolutely correct, my lord.
other
But,
provisions.
my lord, the
We will have to
idea
allow,
is-
accept the rules in complete.
because, my lord, there is.
We just cannot pick up tidbits and bits.
Now, their ground is that, my lord, it's a group B post, my lord. So automatically the office memorandum of 2019, where my lord registration is required, is automatically applied. There, it is their case, my lord.
That's where relevancy is there. Suppose if without any resolution by the agency, if the recommendation of the Sixth Pay Commission has been accepted by the state without any resolution, if it automatically applies, it's a state agency, is not it? Why can't be the official? I mean the executive orders or the notification should not be applied. Issue that's why
That is the only issue.
whether it's a group B or
Group C.
this is a relevancy. Connecting that.
Yes, ma'am.
Had you had suppose if you if the agency has taken a resolution that we also adopt or this will apply so far as the recommendation of the Sixth Pay Commission by the state is concerned. If you take a resolution that this, since the Sixth Pay Commission has been adopted, I mean accepted by the state government, it applies automatically to the agency. If there is a resolution, unless you have another resolution, I mean, so far as the notification is concerned, you cannot just say that all these things, the action of the state government, either adopting or issuing a notification will automatically apply. Is there any resolution?
So applications of Sixth Pay Commissions in the appendix is concerned also. As my senior friend has admitted, lawsuit, this pay scale lawsuit is applicable lawsuit.
No resolution by the board.
By the board, yes, no resolution.
No resolution.
No resolutions.
It is not in my knowledge, man. They have to clarify that.
Because that is not the pleaded case actually. So they have
No, it's not.
Anyway,
this court has noted
Yes,
you
yes.
have not filed any affidavit on this. I mean, challenging this order. It said this may have a relevance.
Yes.
You have to clarify it's a group B or to have a group B or group C because rule has not been amended.
Yes.
It is still a group C.
Yeah.
But you are considering it to be a group B.
Group B.
So
because pay
so
scale
pay
is
scale as per the Sixth Pay Commission
The same
recommendation,
person.
which you have, which the state has adopted.
yes, boss.
Now, if this adoption or the acceptance of the Sixth Pay Commission by the state government, if it automatically applies without there being any resolution, you will have to show from your this association memorandum MOA that it applies. Then the subsequent notification, and not the subsequent notification, which you are relying, so far as the requirement of graduation or the bachelor's degree for Group B post, it will also apply perhaps. But that will have an impact on the claim of the petitioner.
Yeah, Lordship, the important is that, Lordship, as I've said, Lordship, classifications of the pay scale and
Yes.
which category it falls, Lordship. In substance, Lordship, the petitioner, since he's in the post of assistant, Lordship, in substance, this particular post falls under the Group B, Lordship. In substance, Lordship. Only the technical is that, Lordship, the recruitment rule of 2013, Lordship, which was published by the Lordship APEDA. In there, it has been mentioned Group C only. It's only the technical part, Lordship. But in substance, Lordship, because pay scale is the Lordship, the determining, Lordship, for the whether it is Group B or C or D, Lordship.
So according to you, any office memorandum or any action of the state authority, state government applies to your agency automatically,
Lordship, automatically,
without any resolution or without any
to my Lordship,
decision.
so far legal position is concerned, Lordship. To my understanding, Lordship, there must be some sort of resolution, Lordship, because it's an autonomous body, Lordship. And it is basically autonomous body used to be regulated by its own memorandum association or
because unless you clarify this, your ground of supporting your own minutes and the promotion, go away.
That part is
because your basis is this.
That part is
6 pay commission and the classification of things.
That part, Lordship, the Group B, once it has been assumed, as my senior partner has, Lordship, by assuming it is a Group B, Lordship. If it's assumed that this is a Group B, Lordship, then, Lordship, bylaw is very clear, Lordship. The instruction of the state government will be applicable to the, Lordship, APEDA, Lordship. Bylaw it says, Lordship. So far, office memorandum of 2014 is concerned, where it says, Lordship, for Group A and B, Lordship, graduation is required. That part, Lordship, OM makes very clear, Lordship.
That it applies to
OM, the instruction can be issued by the state government to the organization, the government organization.
So this has been issued. Has it been issued to the agency?
Yes, Lordship. To the important OM, Lordship. That makes
it issued to your agency.
Yes, Lord.
Not the state government.
State government as well as to all the departments of the state government, Lordship, as well as to the government organizations.
And you are required to amend your rules also.
Required to, Lordship. And in that regards, Lordship, in some department, Lordship, they have denied the promotion because they were not graduated, Lordship.
Department is something different.
In that case, here, Lordship, because they are in that case.
Why I'm saying, the OM applicability of the OM 2014 or 19, something like that. The requirement has been provided for bachelor degree. How can this be automatically applied?
Because OM, this memorandum of association, it says, Lordship.
What is it? Just read it. Just wait, huh? Let us clear one by one. The basic, let me have the.
Kindly come to the last page, Lordship.
35.
35.
Concluding directive.
Control and directive of state government, Lordship. Over this APEDA, Lordship. The government of Arunachal Pradesh may from time to time issue directives to APEDA as to the exercise and performance of its function as it may consider necessary in regards to the finance and conduct of business and affairs of the APEDA, and in like manner may vary any such directive so issued. So this is the power of the state government, whether it can give any directive.
It has been issued or not?
Lordship. Lordship,
why does office memorandum?
Oh, yes. Office memorandum.
It is issued to APEDA.
APEDA, Lordship. Not only APEDA, this is general direction to all the Lordship, the departments, Lordship, and the government organizations.
Inference.
Kindly come to this.
You are making an inference.
No.
You are
Lordship.
drawing an inference.
No. Kindly come to this, Lordship. OM.
All the state government departments and organizations.
Lordship, kindly come to the OM itself, Lordship. OM is OM is at page 21.
Just read it. Relevance.
Here lawsuit so far
You are
graduation.
drawing an inference. It said all the organization, agencies and all.
Here, here
Just
lawsuit.
read it.
Here. The above decisions lawsuit are brought to the notice of all the ministries, departments, organizations under the government of Arunachal Pradesh for strict compliance. They are also directed to initiate proposal for amendment of the existing service rules,
You have not.
recruitment. Here, lawsuit, the issue of the supplementing lawsuit, because there's a judgment lawsuit, because in connection to one or two department issue came lawsuit, because their recruitment rule was not.
Department were not concerned and were not disputed.
One is lawsuit power to give direction lawsuit. That memorandum of association, it has given that power lawsuit.
No, next step.
Next step lawsuit.
You have not amended the rule. It is still Group C and all those requirement of bachelor degree is not been put in by amending your rules. At the time of consideration of the promotion, at the time of DPC.
Here lawsuit the graduation part lawsuit, education qualification lawsuit. This direction, this directive is
applies to the, let us assume,
lawsuit.
let us accept that it applies to APEDA.
Lawsuit.
What is the next step? After it will apply, but accordingly you are supposed to amend the rule.
Amend the rule.
Unless you amend the rule, what is the meaning of amend?
Therefore, lawsuit, I'm taking lawsuit.
What is sensitive?
This case lawsuit passed by the division bench of this honorable court lawsuit.
Filling the gap.
Where filling the gap lawsuit. Lawsuit, there also rule was not changed lawsuit. It was not amended lawsuit.
No, it's not a question of amending or not. In this case, the requirement is this. You are changing the requirement.
Lawsuit.
Rule 13 says
Lawsuit.
you don't need bachelor degree.
Lawsuit.
Is not it?
Lawsuit.
And no, the persons who have completed 5 years.
For the degree holder is the 5 years.
Yes.
And for the non-degree holder is the 10 years.
10 years.
8 years.
Lawsuit.
Is not it?
Lawsuit.
It's clear provision is there. So unless you amend that.
Lawsuit for what I'm submitting is lawsuit. The same provision also was given in those recruitment rule lawsuit. Where it says lawsuit for promotion lawsuit, length of service was given lawsuit. This honorable court held that lawsuit. Though that recruitment rule has not been amended as per 2014 lawsuit. But even then lawsuit, so far education qualification is concerned, that is not given in that RR lawsuit. Exactly in this present rule also that
You have given here. For degree holders 5 years. And non-degree holders 10 years.
Lawsuit.
When there is a lacuna, then the executive instruction can supplement the rules.
Supplement. Cannot be supplant.
Cannot be supplement.
The same thing lawsuit. Here lawsuit the qualification lawsuit. Education qualifications, whether required or not lawsuit.
It's okay. Okay. You continue.
Yes.
So according to you, whether resolution, no resolution, as per the MOA, there is a provision for a power to direct the APEDA by the state government.
Lawsuit.
This
power is there.
Therefore, once the moment state takes a policy decision, issues a notification on office memorandum, it will automatically apply.
Lawsuit. And so far lawsuit, the adoption is concerned.
Besides that, as per the memorandum, it says including the organization, which is the APEDA.
Lawsuit.
And of course, there is no rule. A rule has not been amended, but there is a direction in the office memorandum. Though it has not been amended, by since the rule has not provided clearly for this requirement of bachelor degree. So it's a act of filling the gap by office member.
That's
supported by your division bench.
Lawsuit. And before that lawsuit, so far lawsuit, the adoption of this 6-pay commission is concerned, whether it's automatically lawsuit applicable to APEDA or not. Lawsuit, that part lawsuit, I have no instruction lawsuit. And as I've submitted lawsuit to my legal understanding lawsuit, there must be some sort of lawsuit adoption lawsuit, as provided under the memorandum of association. Because it's governed by the memorandum of association only. What is permitted and what is not permitted, lordship, is given in the MOA only, lordship. If it's permitted, lordship, then that can be, and if it's not permitted, so for this last part is concerned, the control of the.
This is general, I mean, the kind of provision, it's not specific.
Lordship.
It ought to have been that any decision or the direction or the by office memorandum, whatever, should be applicable to the agency, should have been. It's you can control them. As per this.
For management.
Management of the
Close.
affairs and all.
Close.
So you are trying to draw influence that
So that,
any decision and all these things has to be.
because here, lordship, the direction is, if lordship see the language, lordship, it's wide, lordship. It can touch the activities and including the service condition, lordship. And automatic application is concerned. One, this is two different things also. The 6-pay commission applicability.
What is the, you are drawing the salary. Are you drawing the salary as per the 6-pay commission? Is that of, like that of the state government employee? Yes. Are you? Yes. Sure. Yes.
Pay scale is not disputed. I think my senior friend also is not disputing.
Problem is you have
not on the group D or C post matter. Basically, I'm on the rules matter.
Sir, rule is there, but then to come to that, we need to have a basic understanding of whether it's a group B or group C. As per rule, it's not still, it's a group C.
It's a group C.
They are saying practically it is a group D because of the 6-pay commission, which the state has adopted, which equally applies to you, applies to the agency. So these are the, I mean, there's a connected relevancy.
Yes, madam.
Otherwise, simply we can say that since rule provides, no, you have not amended, you cannot apply this. I think that cannot be a proper course of deciding the matter.
Then lordship, there, if it's allowed lordship, then there will be two group lordship in the assistant post. One is lordship.
But it's all your creation. If you are, if you think that, if you accept that this is, this apply, they accept, I mean, any notification by the state government or the policy decision applies automatically. Why you have not amended the rule? First part you said it applies, it includes the organization, includes the APEDA. Further, next step is you have to amend the rule. You have not amended it.
So far, amendment is concerned. That has to be done by the lordship, the APEDA head themselves.
You are for APEDA or not? Are you for APEDA?
Yeah, I'm for APEDA lordship. Here and so. and one more thing, lordship.
No, you first decide. Are you for government?
Yeah, I'm for APEDA. I'm for APEDA.
Is there government?
And
government is there.
Yes, I'm appearing.
No, you can apply for.
And one more
conflict. You appear for APEDA, appear somebody ask somebody to appear for government in this matter. Because
correct.
Maybe under the control of the government,
no,
but it's difficult.
No, that's I understand. And one more aspect, lordship. So far, this recruitment rule of 2013 is concerned, assistant. In that regards, lordship, our state is there, lordship. That is under the draft lordship, lordship.
Which one?
The rule of 2013 lordship, assistant rule. That's not lordship duly notified lordship by the governing committee.
But then you have on the basis of this 2013 rule only, you have had a DPC and a promotion has been given.
Lordship.
Then even if it's notified, draft rule can be
just apprising the status lordship. When draft rule is there, lordship, we are following that. That also is a statement is there, lordship.
You can have a draft rule for 10 years or 15 years.
At that part, lordship,
I mean, the agency should have worked better than the government department.
Correct.
It's worse.
Correct.
It appears to be worse. It has to be not the government officers.
No.
Let it be privatized.
No, sir.
So it's not still clear whether this
Automatic application.
automatic application. Can you ask him to, is there urgency? Promotion is.
Rule requires my lord 5 years of length of service.
Listen, my discord triumphancy of the view that for so far as the rule, not amending the rule and the relevancy, the grounds which you are relying. Triumphancy, there's no problem. Discord wants would like to understand whether this, in case tomorrow, this court holds that if rule is not applicable, the recommendation or the adoption, 6-pay commission is not automatically applicable. If we find that this is something, we'll have to determine on that basis. Because practically it's a Group B post now. But rule says Group C.
Because it was, framed in year 2013.
And the basis of promoting him, considering her case, except allowing her to complete, is based on this, it emanates from that only. 6-pay commission as well as the office memorandum. Isn't it?
6-pay commission.
Once you have the clear graphs of how it, made applicable, then only consequences determination can be, clearly made.
Because I am challenging the very proceeding of the DPC matter. DPC has admittedly taken the rules of 2013 and admittedly finds there is a finding that the private respondent has completed only 4 years of regular service in the great matter. The requirement is 5 years matter. And further matter, I am a non-graduate. I have completed more than 12 years, 10 years in the federal, more than
13 years.
13 years in the federal. So, in that context also, the DPC has to be set aside. Now, the consequence on setting aside of the DPC, basically, naturally directs for a fresh DPC. Now, even assuming that, now it's a Group B post matter. Now, I have also qualified matter. I have also acquired the degree matter. Then that will be considered before the fresh DPC.
No, to quashing the DPC minutes. The DPC is based on all those members.
Yes, madam.
To find out whether the DPC, the consideration by the minutes is bad or good. This is proper or not. So we'll have to first determine the basis of that. The basis is the office memorandum and the 6-pay commission, Group B. So that I would like to, that's why before hearing you in full, I just wanted to know. Because that is the basis. Unless we determine that first, how can we just say that this is not proper? The minutes of the DPC. This is the view of this court. As you know, you may be why this court doesn't understand and my case is very clear and all this. Maybe you may have that perception and you may have that. And he may also have the same thing. You समझ में नहीं आ रहा kind of thing. So will ultimately this court has to determine. The basis is not. It's a cloud is there in the basis. Otherwise, if by accepting your submission, there's nothing. You can dispose it of now, no issue. Clearly, it violates the recruitment rules. Yes. That's all. But there is 10 will have to determine. It cannot be one-way traffic. Isn't it? So we'll what do you say?
Then was it in that case was it automatic applications part below? I maybe come with
how it applies, whether it on the basis of the resolution or in view of the provisions which you have referred.
Yes.
35 or something like
since
that.
adopted
Clause
by the-
35. Is any decision or the notification by the state government applies automatically, or the board has to take a resolution? Number one. Number two, that your not amending or draft rule, what is the status? That you can also clarify. In any case, even if it's a draft rule, you have relied on, or otherwise also if there's no other rule, you have to, there's no bar. Can be.
It cannot be said as a draft rule because the board has passed a resolution to that effect and the chairman has approved that resolution. That becomes the final rule.
So we'll defer it. Substantially, I have heard it, but this is something I would like to have. Because yesterday while going through the petition, they still, that's why I'm sorry that I did not hear you and started jumping on you. Yours, it's very clear, whatever. I have heard you.
Let me, my friend come with clear picture.
Lordship, so far past query is concerned, if that can be reflected in the order itself.
Our Mr. Our Secretary, Learned Council to the petition. And also the stuff in Learned Council. And then senior government advocate for respondent numbers. For status, for nine, not the status.
1, 2, and 3.
For respondent numbers.
The affidavit is being filed by 2 and 3.
2 and 3 by?
The chairman of the board and the director of affidavit.
Okay. For Mr. For respondent number? 4, 3. 4. After hearing the Learned Council for this person, this court finds that whether they finds that there's no clear instruction on behalf of the respondent as to whether any action, public policy decision, public rules, public notification automatically applies to the APEDA. To the APEDA without any resolution to that effect by the board.
The rules automatically rule making power is within
the rules will not say notification. Notification. Policy decision, public notification, will say etc. Mr. Tapin, senior government advocate, is directed to obtain the instruction on the next date fixed, either written or orally or in written. We'll consider that. So, obtain instruction on the next date fixed. When? After 2 weeks. This matter after 3 weeks. 2 weeks. We'll release one partner.
Let it be partner.
In case if this code doesn't come back, you may have the BC also. Because these are the only things.
Yes,
And formally I'll hear him.
yes.
For a few minutes.
It will be better for me when they file the instructions in the form of affidavit.
Affidavit.
We'll
It's
filing it.
obtain the instruction and file affidavit. So use this keep it part of it. The method is this part of it.
We have interfered with the, what do you call that, criminal proceedings, and we have given our reasons for that. Right? And we have also noted the submission of the parties that they had appeared before us, and they consented that your apprehension was also dealt with. Well, same order, same reasons, and we have also paused here the proceedings. I only referred to two judgments. The others have not gone into B.S. Joshi and Gyani. Then I'll sign it. You will have the copies after some time.
May I please, my lord?
Yes.
Item number 8, I need to file affidavit, so I need 2 more weeks to file my affidavit.
My lordship, 3 weeks may be granted, lordship.
You are appearing for?
I am for respondent.
BRS metal. 3 weeks may be granted. 4 weeks.
What was the issue here?
Issue lordship BRS metal. Voluntary.
How many more? 2 weeks.
2 weeks.
On a prayer made by
G. Tarak,
G. Tarak,
Standing Council.
Standing Council, Rural Works Department, for grant of further time of 2 weeks to file the affidavit on behalf of the respondents. The matter stands adjourned to be listed on a date. Matter stands adjourned for 2 weeks to be listed on a date to be fixed by the registrar.
Okay.
May I lordship? I beg to mention item number 11 and 12 and 14, your lordship, on behalf of J. Gini, leading counsel J. Gini, your lordship. He is having ill health, your lordship, therefore.
These are 14 I can adjourn, but 12, maybe some orders is required to be passed. CP here, no adverse orders will be passed. 14.
14, yes. After 2 weeks, your lordship.
On a prayer made by
T. Tarin.
T. Tari on behalf of J. Gini.
Yes.
For an adjournment on account of ill health, personal inconvenience of J. Gini. The matter stands adjourned for 2 weeks and would be and be listed thereafter on a date to be fixed by the registrar.
Your lordship, another matter, this is item number 11, your lordship.
11, you just wait. It's an
Okay.
order matter. So
Okay.
let's see if something is
Okay.
done.
Thank
We'll not take it up on that.
May, my lord. I beg to mention item number 7, my lord. Item number 7, my lord. My lord, I'm mentioning on behalf of K. Lawyer, my lord. Due to some personal difficulties, he is not appeared today.
Just give me a file of some. Just a minute. You are in the matter,
Yes.
not taking it up on merits, just wanted to say that I made some note. You are appearing for the petitioners.
Yes, ma'am.
The respondents have already filed an affidavit. You don't want
Yeah.
to file a reply.
No, no, no.
No reply.
No, yes. I've taken the question from other.
Okay. Then we'll fix it. We'll say that you're not filing any reply.
Yes,
A rejoinder, and we'll fix it for the admission hearing.
yes.
Mr. What's your name?
T Taggu.
T.
Taggu.
Tagbum.
Taggu.
Tagbum. Learned counsel for the petitioners. Submit that. The petitioners would not be filing any rejoinder to the affidavit filed by the respondent number 3.
One-
Just check up.
all the
By
res-
by
all the
respondents.
respondent.
Respondents, full stop. Accordingly, list the matter
After 2 weeks.
for admission hearing after 2 weeks on a date to be fixed by the registrar.
Much obliged.
Madam. No, I'd like to mention item number 2, madam.
Item number
2, madam. Leading counsel is having a difficulties, madam. So the matter may be adjourned for today.
on a prayer made by
The other, madam.
T. Allo.
The other.
D.
The
Yeah,
other, the
D.
other.
Allo, you're for the respondent.
Yes.
On behalf of the respondent, sole respondent, for an adjournment, comma. The matter stands adjourned to be listed after 2 weeks on a date to be fixed by the registrar.
Much obliged.
Lordship, would like to mention item number 13, Your Lordship. May kindly take up this matter after 3 weeks, Your Lordship. We have to file affidavit in this matter.
So what is the issue involved here?
It's an appointment, Your Lordship. Appointment of the private respondent. The
Mhm.
petitioner is challenging the appointment of the private respondent.
I think there is a stay order also.
Lordship,
Hmm?
yes. Stay order was
That work charged.
Yes, yes.
Work
what-
temporary work.
And the private respondent, what we do is, just hold for a moment, they have taken dusty service.
Lordship,
So what we'll say that the service is complete
okay,
and we'll fix it for admission hearing.
Lordship.
Just let the matter be called.
Lordship, this matter is appeal against the
Order.
VC.
There is already a stay order
Yes.
and there is a notice note saying that fresh steps upon respondents number 1 to 17 not taken. I find nobody is appearing for the respondents also.
In fact, all notices have been served.
Notices have been served,
Yes.
but there is nothing on record. You have a Lauzima court here? A register court? No. It says that register. Your name?
Arco,
Arco,
appellant.
learned counsel appearing for the appellant submits that. Steps on the respondents have already been taken. However, the office note dated 10/10/2023 reflects that fresh steps have not been taken. So, because there was an order of 25/4/2023 asking you to take fresh steps. Anyway, full stop. The raised to ascertain the status with regard to service of notice upon the respondents number 1 to 17 and submit a note. Full stop. The matter be listed on a date to be fixed by the registry after 2 weeks. Fine? Because there is a contradiction what is it. So let's have it clear.
Your Lordship.
Hmm.
Lordship, here already we went a file by the petitioner. And here,
It's the termination matter.
yes, Your Lordship. Here, Learned Senior Counsel, Mr. P.K. Tiwari will appear on next week. So I pray that Your Lordship, matter may be fixed on 7th December.
The only thing you can get here is, see, admittedly, the whole period you are not there. Admittedly, the whole period you are not there. Anyway, the only thing you can get is that they do the part when you are not in service and regularized as UL, they can fix your pay notionally so that you get something more for your pension. But the ACP and other benefits and interfering with this or disciplinary authority, appellate authority's order, be too far-fetched. Anyway, think over it. But yes, that regularization of that period for the, because they have already said that it will be counted for pensionary benefits. So notionally, that increments, you get a substantial sum then. Try in that language. Heard, Mr.
A. Bhattaji.
A. Bhattaji, Learned Counsel for the petition, who submits that the arguing counsel is not available and prays that the matter be taken up next week. No objection?
Lordship, not next week, because Lordship, I have,
Problem.
yes, so many cases already, Lordship, fixed cases.
I have been instructed by the Learned Senior Counsel.
But she also, with her convenience also has to be seen.
Petitioner have taken continuously.
I've seen that. Initially, they were very active. I'll not give a fixed date. I'll only say next week. I'll not give a fixed date. I'll say 1 week, because some senior is coming. We will be also in trouble. Next week, you take an adjournment.
Yes, I have been instructed so to take on.
She also has to consent.
Maybe after week.
After 2 weeks.
Here already every all your
yes.
We have been absent. We have not taken time of the 2-3 occasions.
Not 2-3, more than that.
Yes.
What we have written?
Last
night. Taken up after a week. So they said prayer is objected to by the Learned Counsel for the state respondents who expresses inconvenience on her part to have the matter next week. Accordingly, the matter stands adjourned. And be listed on a date to be fixed by the registry after 2 weeks. So whenever he comes next time, you make a prayer. Whenever he comes next time, make a
I
prayer.
have been instructed by the senior.
Huh?
I have been instructed by the senior.
Put it 1 week. Put it 1 week. You make a mention. She'll object then. 1 week. Huh?
1 week. Oh, like.
Because see, the conduct here is very bad.
He was never here.
I know that.
Till now he.
No, the
Yes,
conduct on your
in
part.
this case.
See, because this matter is adjourned repeatedly on behalf of the petitioner. They have not taken time.
Actually, also the senior counsel is not.
No, it's not never mentioned that if there is a senior counsel here. It's on your name.
Yeah, earlier I have taken adjournment on myself here also, but no.
After 2 weeks, go here. Maybe 2 weeks. You make a mention before the bench. They may permit you.
Oh, oblige you.
Wait,
What to do?
if it is not inconvenient, my lord,
We can hear it. But the only problem is I'll not be here next week.
in that case, my lord,
Just a moment. Just one clarification, Mr. Pani. They have filed the SIT has filed your case is that a charge sheet has been filed
yes, already.
and you are not figuring them.
Only
Till that extent, it was good. Okay. They say only with regard to taekwondo and karate, they have some issue. You are for, I think, you are.
one is football and one is
What?
archery.
Archery. Now, the affidavit that they filed, I've seen that they are saying that our investigation is not over. We have filed a charge sheet with whatever details the associations have
I've seen
submitted.
that.
Karate and Taekwondo had come up, but the other associations have not come up. So what we do is we ask the council, because otherwise, if it is, there is nothing against you.
Yes.
There is no point in keeping you hanging. They should take it to its logical
And the
conclusion.
extent of the department is once they return the report.
I found it. This affidavit really stopped me. Otherwise, I thought of proceeding in the matter. But when I saw this affidavit, because the clean sheet has not yet been given.
But they have. We
So
are
they
not
can
accused.
find-
They have just filed an affidavit saying
No,
that
no,
the
no,
investigation is not complete.
complete, because they know there is another reason here. Why, if it was that much, I would not have even bothered. The reason is that the associations have not responded. That's the stand. We have written to the associations for clarification and they have not responded. So who is appearing for the sixth?
I'm appearing, my lord. My lord, in addition to that, there is no disclosure of a Caesar list against which they are seeking a direction.
No,
There's no disclosure at all.
that may not be material, because in your affidavit, you say that we have only got till now against
They can invoke the provision of section 457 where they can approach.
why should they?
There's an
They were-
alternative
they were
remedy, my lord.
candidates. They were candidates and there
Yes,
is an apprehension. Clear of that apprehension. If
Yes,
you have nothing against them, there will be no charge sheets file, you'll be closing.
Yes.
But here you say because you don't get information from the concerned federations or the associations, you're not in a position to take the matter. What we are proposing is, we'll fix the matter after 2 weeks. In the meantime, you get a status report.
Case diary, my lord.
I don't want the case. Get a status report. As to
Whether
the
any investigation against these persons who
petitioners, if there is anything,
not only the petitioners, my lord, because there were 10 persons who appeared in the.
we'll only confine ourselves to the petitioners. Archery and this, let them bring it on record.
My case is, my lord, there's been a selection process.
I got it. Because the manner in which this affidavit has been filed,
Yeah, I
that we have not, that is the only, otherwise initially my
But there has
view
to be
was we can dispose of this.
some material there to say something they are proceeding.
There is
against,
nothing.
There
See,
is nothing.
The only thing here is, they say we are writing repeatedly to the associations, your respective association. The petitioners so-and-so belong to archery and football discipline respectively, and they are still under investigation. So what we do is, we'll ask them to get a status report on this. And on the next day, they will disclose whether there is any material against it.
Yes.
Or if there is nothing, you can also do one thing, because the stand here is associations. I'm not advising, think over it. You can implement those associations. You can give a notice to them, or you can get some material with regard to your certificates, which may be satisfactory to us here.
It would be better, my lord, the association, I don't know if they will respond or not.
That's also, let them.
The status report in respect of two petitioners.
Two petitioners.
What is the state of investigation? What are they doing, man?
No, we only want to know what you have against them.
Yes.
Others, what you do is your matter.
They cannot just sit over it and not return the report.
And somewhere I think I read that those things are also not with them. That I think is also one of the stand. Anyway, the issue involved in the present proceedings pertain to non-appointment of the petitioners.
Non-declaration of results.
Non-declaration pertain to non-publication of the select list in pursuance to a selection process undertaken specifically for filling up the quota in various services for sports persons. Just correct me if I'm wrong.
For the post of junior engineer.
Junior engineer
In the Department of Power under the meritorious sports person.
in the Department of Power under the meritorious sports person quota. Full stop. The set selection process was not taken to its logical conclusion on account of an investigation by the Crime Branch SIT, Police Station PHQ, Itanagar, with regard to the bona fide of the sports of the certificates produced by the by the candidates appearing in the selection. Full stop. The investigation on being concluded, a charge sheet being charge sheet number 5/22 dated 17/3/22 was submitted before the concerned court. However, full stop. However, therein no allegation has been made with regard to the petitioners, with regard to the certificates produced by the petitioners. Full stop. In the affidavit filed in the present proceedings by the respondent number 4, that is the investigating agency, comma, it was stated that it was stated that further investigation is ongoing to unearth use of similar fake certificates in other sports disciplines. Also, it is also the contention that the investigating authorities had approached various sports associations involved for verification of the certificates produced by the candidates participating in the selection process. However, responses not being received, the matter could not be taken ahead. The investigation could not be taken ahead. Full stop. You will be appearing as the learned PP.
Yes, PP, madam.
Mr. T. Sering, learned PP, appearing on behalf of the respondent number 4, submits that the investigation is still progressing, and in the event materials are unearthed, supplementary charge sheets would be submitted under the relevant provisions of the Criminal Procedure Code. Full stop. In view of the above position, I require the learned counsel for the respondent number 4 to place on record a status report highlighting therein the steps taken by the investigating agency, comma, with documents, comma, for ascertaining the genuineness of the certificates produced by the petitioners in the selection process in issue. Full stop. The learned counsel appearing for the respondent number 4 is granted 3 weeks time to place on record the said information. Full stop. Accordingly, list this matter after 3 weeks. You want a date? I did 3 weeks ago. 3 weeks on so and so. Kindly get, and you also get the documents that you have said that you have written letters.
Yes, ma'am.
So kindly get those.
It cannot be a case that they wrote a letter in 2021 and sit over it.
Because it's because if there is nothing against them, they should not be punished. Even at the same time, with your affidavit, we are also hentai to proceed now.
Yes, that is the difficulty. They have not placed any material on record
No.
showing what they are doing and just told
That's why I've asked them.
Yes.
Kindly
yes,
get
yes.
that if something is there, we'll finish it.
All right.
Thank you.
Here, my lord, issue involved is, my lord, the recruitment rule itself mentions that there should be a.
No, but tell me one thing. You were incorporated as a junior engineer, or you were direct recruit assistant engineer. Here I find that there are 2 streams: direct assistant engineer electronics, assistant engineer electrical.
Yes.
How is the how they are adjusted in the service for promotion?
There's a quota system.
How?
First 75, then 25 for electronics, mechanical and electronics.
75 for the electrical, 25% for this. Now, these posts are lying vacant for a long time. And there is a provision for seniority also.
Yes.
Seniority list. And it's a selection post. Now,
All we want, my lord, is that let them prepare the seniority list, my lord. That is a mandate of the rule. That is all we are asking for at this stage.
but
They
what do you
are
say?
just not responding, my lord.
You have not even filed a
Nothing, my lord.
counter yet.
Yes.
I'm praying some more time, my lord.
My lord.
See,
I don't
time
wanna say
is
it
of
is the
no,
last.
we can grant you time till eternity. There is no problem. But the thing is, at least a person is before this court. We must know why his grievances are not being addressed.
My lord,
Because prima facie, if there is something in your part, it's a different question altogether. But if we examine the rules, another thing, you can also say one thing, that there is no post available in the promotional cadre. So we are not prepared. Fine, enough. That's a genuine reason. But say that.
no, my lord, that is not, but my lord.
If you have vacant posts, you have necessity of these people.
My lord.
Why don't you promote them?
My lord,
Take that. They are not praying for a promotion. They are
No.
only praying for a select list.
Interest, my lord, my humble submission would be, my lord, kind of, there's other aspect of the matter, my lord. There's a other part is promoter is also there, my lord. Now we are in consideration, my lord, in the
We
process,
are
my lord.
least bothered who you are, who the people are. We are only bothered here in this proceeding is that the persons they are claiming that in terms of Rule 27, I suppose, Rule 27, the gradation list is to be prepared. You are not preparing, and then you are not conducting DPCs for their promotion. Maybe they have an apprehension that without the seniority list, if a DPC is held, it might be on a pick and choose basis. Anyway, it will be a selection post. Seniority will not matter, but still, if the if the merit is equal, then the seniority position would be relevant. So what we do is, we fix this matter after a week. You get a written instructions. I don't want an affidavit. Get a written instructions from your authorities as to the reason why the select list, the seniority lists are not being prepared and why the promotions are not being done. Anything you may, I'm not saying that you must do it. I'm only saying if you have not done it, why you have not done it. That reason. Fine.
Only, my lord, my humble, let it be 2 weeks, my lord, for the, to get the instruction to prepare the inter-seniority, my lord.
No,
Promotion is,
I will not order you to prepare inter-segregation list. I only want to know why you did not prepare the inter-segregation list.
My lord, my oral instruction would be, my lord, we in the process, my lord. Now that's why, my lord, my humble submission, my
You
lord.
mean to say that the seniority list is being prepared?
Yes, my lord. Truly, my lord. Provision also we have issued, my lord.
The record by lord different submission.
Mr. I can record that.
In process, my lord. That not finalized, my lord.
No, I'm saying that it's in process
My lord.
and it will be concluded within a period of 2 weeks.
My lord.
Yes,
My lord. That's why, my lord.
It's nothing. How many people are there?
My lord.
How many? No. How many in the cadre? How many people would be there?
Cadre, my lord, promotees, I'm not.
Anyway, 50, 60?
Yes, that.
That's why, my lord. That
You
why.
only have to take the date of promotion. You will have to take the date of direct recruitment, consult the APPSC merit list.
No, my lord. There is other aspect of the matter, my lord. That's why I have submitted. There is other aspect of my lord. Kindly consider, my lord.
We want to know what the other aspect is. That's what we are trying to get out from you.
My lord. Other aspect is, my lord. There is my lord. We are the employer. There is two part, my lord. One promotee and one direct equity, my lord.
See,
we need to consider the grievance of the board, my lord.
If your authorities have a wrong notion of that matter, file an affidavit, 1-page affidavit that because of the promotees and the direct recruits existing, we are not in a position to prepare.
No, my lord, that not only is, my lord.
We will tell you how to do.
My lord, since long, my lord, since long, my lord, this has been not prepared, my lord. Since long, this was not prepared, my lord. That's why, my lord.
Who has gone have gone from the service.
Truly, my lord.
Who are there? They should know their status. They should know their position.
That's why, my lord. This is in under active consideration, my lord. My humble submission will be, my lord. My lord.
I'll handle it. Mr. Sorry, you.
El per me, my lord.
El per me. Learned counsel for all the respondents.
Yes.
For the respondents submits that the seniority list of the members in the cadre of assistant engineer electrical is presently being prepared and the relevant data for the same is being collected. Also, the present proceedings were the present proceeding was instituted on 28/7/2022 with the specific prayer that a seniority list for the said cadre is to be prepared. Full stop. Taking into account the submissions made by LPM, government, additional government advocate?
No, my standing council.
Standing council of Power Department.
Power department.
Standing council, Department of Power, comma, the matter stands adjourned for 3 weeks. Also, on the next date fixed, Mr. Permi shall produce before this honorable court either the seniority list, if prepared, or if the seniority list is not prepared, finalized, even if the provisional seniority list is not prepared, a written instruction as to why the provisions of Rule 27 of the Arunachal Pradesh Power Engineering Service Rules 1993 was not complied with by the authorities. How did I start that line? On the next date fixed. On the next date fixed, comma, without fail. These are small issues. You should try to finish it up. Publish a list, let them then fight it out that their seniority positions are not correct.
What is actually happening is, it is one in this state. They are giving these officiating promotions to this.
There is a matter also.
Yes.
Yeah,
So now these people are claiming that they should be given their seniority from the date on which they were given office. That is the issue, my lord, nothing else. That is why the department is not even responding to my learned friend.
I do that. Now I have given him a handle. You do it.
My lord, may I pray a copy of the order, my lord?
A copy of this order be furnished to Mr. Pami, Standing Council, so and so.
High level.
I think they should do the work.
Yes, yes, this is not right.
Lordship, here I need time to file affidavit on behalf of state respondents 6 and 7, Your Lordship.
Now, I have not understood the manner in which you have proceeded. Your affidavit would be required.
Yes.
What do you say?
We will wait, yes.
The other affidavits that have been filed.
Their affidavit is necessary for the proper
Who
conclusion
are
of
you?
this matter. Yes.
You-
Finance, Your Lordship. State
Finance.
Finance, for finance, Your Lordship.
Some affidavits have been filed.
Yes.
Yes.
Election, APPSC is not it's not a major party here. The other affidavit has been filed by Commissioner Tax Excise.
Yes,
Narcotics.
respondent 2 and 3, they have filed, Your Lordship.
This GST thing does not come under the finance. It comes under the finance only.
Yes. 6.
I think you also should look into this affidavit of the Commission of Taxes. Because certain statements have been made there that the post of UDC is a promotional post from NDC. They have referred to a decision. But that decision, while being implemented, it came that UDC would be the taxation officer. And So it's only that decision which has been published, which you can challenge. The decision-making process may not be open for challenge in this case. Anyway, you'll be filing the affidavit by
6 and 7.
on 6 and 7. Yes, so and so appearing for the respondents number 6 and 7. Praise for 2 weeks time to file the affidavit on behalf of the said respondents. Or you were implemented subsequently.
Yes.
6 and 7, no?
Yes.
So accordingly, prayer is granted. List the matter after. We'll give you 3 weeks so that you can get it. 3 weeks. List it after 3 weeks on a date to be fixed by the registry. If it is not listed, make a mention.
Yes. All right.
Obliged.
Counsel for the petitioner is not present.
For one only, Your Lordship, Standing Counsel Education is also absent today.
Pardon?
Counsel for Education Department, Standing Counsel.
Okay, they are also not here.
Yes, I'm for one only.
What do we do with this? He has lost interest. Got another job somewhere. So it's a contractual appointment, and show cause was also issued. Thereafter only the termination.
Yes.
Anyway, none appears on behalf, none appears for the petitioners on call. Stop. For the ends of justice, list again. After three weeks on a date to be fixed by the registry. I think those are outstanding, outstation from body, I think they have done. No.
No.
My lordship. Lordship, thus the steps on the respondent was taken on lordship 3/10/2023. However, Your Honor, I have taken the steps upon respondent number 3.
You have been saying that
Yes,
for the last 2 days. Now, where is the
Lordship,
affidavit?
what is happened, Lordship? After taking the notice and the petition, Lordship, private respondent has refused to acknowledge the same. That's the difficult.
You file an affidavit to that effect, sir.
Lordship, I may be allowed to file affidavit. Lordship, in the meantime, usual process may be allowed.
Wait 1 minute. Let's see who is the authority. Ma'am, you are appearing for?
Okay, for 1 and 2.
1 and 2. Where is that respondent number 3 posted now?
0, Lordship. Lower Subansiri.
Lower Subansiri. Can we direct that a copy be served on the, who is the, below the commissioner, who is there? What is this department?
Department of Hydropower.
Hydropower.
Hydro.
There will be a director?
Lordship.
Huh?
Secretary, Lordship.
Secretary, Commissioner,
Commissioner,
Secretary.
sorry.
Can we direct that the copy on respondent number 3 be served to him, because he's not accepting. Registered post is also not going.
Okay.
Would it be inconvenient? Anyway, Mr. You file an affidavit, then only we can pass that on. Mr. L. Nochi.
L. Bam, Lordship.
L. Bam, so and so. Counsel for the petitioner submits that. the affidavit as required to be filed pertaining to the service of notice upon respondent number 3 by Dusty would be filed within a period of
Week, Lordship.
7 days from today. So it is also the submission of Mr. So-and-so, learned counsel for the petitioners, that the respondent number 3 had refused to accept the copy of the writ petition served upon him. Also, further orders that may be called for in the matter shall be so passed after filing of the affidavit as stated above.
May Lordship.
This again.
Lordship, they
after
had
10 days. At least again on after 10 days, give a date. At least again on so and so date will give you. And it is expected that prior to the said date, the affidavit as referred to above shall be filed by the counsel for the petitioners.
My Lordship. Lordship, they have received the petition copy, Lordship, and the original.
Whatever
notice
is there, you write it and give it, because oral, because there is already a requirement. Now tell me one thing.
Yes.
You have claimed that you have a BTech degree also. But have you appeared in that AICT examination? No. No. Because that is from the Rajasthan Vidyapith. And tell me, you satisfy this court also on one thing. Because all your appointment orders says that this will not give you any right, officiating promotion. It will not give you any right. Now, how can you claim that it should be, that your officiating that date should be taken as your seniority? Thirdly, you are at 41 and 42 of the seniority list. You claim 23 and 24. Now, are you not required to bring on record those people who would be deprived, whom you are trying to jump?
Yes, sir.
Think over it. I'm not passing any order today. Think over it.
Okay.
And ma'am, you also take note of this fact.
Okay. My Lordship, I am appearing here on behalf of Spinter Picture.
Yes, sir. I know that is. You have not filed the Dusty service.
Yes,
the
Your Lordship.
affidavit.
On last occasion, we were directed. We have taken Dusty service, and we may be given 1 week's time to file the Dusty service.
Okay. Because from August you are making this prayer. August, June. You are making this prayer from June onwards.
Yes.
The last chance. Heard Mr. So-and-so, learned counsel for the petitions, who seeks a further adjournment for 2 weeks, for a week, to bring on record the affidavit of the Dusty service, the affidavit pertaining to the Dusty service affected upon
Loan respondent.
the sole respondent.
So,
So, the prayer is accepted and the matter be listed next Friday, or you put it on the Monday next date, not next week, the week thereafter, Monday. 15th. List again on 15, 12/2023. It is expected that the affidavit as noted above shall be filed by the counsel for the petitioner before the next date of listing.
deeply obliged.
The order matters, because if these orders are not passed, it will be just an adjournment.
Yes.
So that's why I asked it late. Yes, ma'am. You're there.
Yeah, no, Lordship, I was mentioning this item actually.
Okay.
On behalf of Jumgam Jini.
We have passed an order today, 2 orders, judgments we have passed, wherein this compromise thing has come in.
Yes.
We have recorded 2 judgments there. One is not of relevance because that is matrimonial issues. The other one, Gyani Singh, kindly read that, whether in this case, we can exercise our powers under 482 to quash it, because it goes a slightly beyond a private dispute. See to that. Ma'am, you also.
Yes, yes, Your
Because
Lordship.
that principle, because here, there is a violence which goes beyond a private dispute. So whether we can exercise our powers, that you will have to satisfy.
In that
On-
case, Your Lordship may fix this matter on coming Tuesday, Your Lordship.
Okay, fine. As prayed for by the parties to the proceedings, list this matter for list this matter
On
for list this matter on Tuesday evening,
5th of this month.
5/12/2023. Good stop. The interim order passed earlier shall continue till the next date of this.
Deeply.
Deeply obliged.
Done? Ready?
May your lordship, lordship, Dusty was taken upon private respondent number 6 on 13/10/2023, and to that effect, affidavit has been filed
Okay,
on 9/11/2023.
but none has appeared.
No.
But one thing I've been doing, I'm really impressed with the drafting standards. It's good. Even in the affidavits, really, keep that up. 90%. It's just go through it, you understand. And this is good. It reflects the standard of the bar.
Lordship,
Yeah.
obliged.
And this is something which came to my notice when going through the briefs. Good. Peruse the affidavit filed by the petitioners on 9/11/2023, bringing on record the service of notice effected upon the
Respondent number 6.
respondent number 6 by Dusty Mill. Stop. Accordingly, the service of respondent number 6 is held to be complete. Stop. List the matter. Madam, you want to file any?
Affidavit, Your Lordship, I have to file.
So, Ms. So-and-so, learned counsel for the, you are appearing for all the government.
Yes,
for
Lordship,
respondent number
1 to 5.
5,
Yes, Lordship.
praise form and is granted
4 weeks, Your Lordship, may be
4
granted.
weeks further time for filing an affidavit, filing affidavit on behalf of the official respondents. You know,
Lordship,
will do.
stay order.
The interim order passed on
9/10/2023.
9/10/2023 shall continue till the next date of this day. If you don't pray, how can I pass?
Lordship, obliged.